Good morning. It's a privilege and a pleasure to welcome you to today's Elville webinar series presentation. Our topic today is Understanding Estate and Trust Administration, the Postmortem Process for Estate and Trust Administration Explained, presented by the one and only Managing Principal and Lead Attorney of Elville & Associates, Stephen Elville, and I'm Jeff Stauffer, Community Relations Director at the firm, and I'll be your moderator today. And we have several new people attending today, so welcome. And we have some housekeeping items as well. So we encourage your general questions today. So please note them in the questions panel on your screen, and we'll pause periodically to address them. And your questions really help drive the presentation a great deal, so thank you in advance. And yesterday by email, you received the presentation slides and 2 checklists that Steve will be referencing throughout the presentation. And if these materials did not get to you for some reason, they're also available in the section marked handouts in the panel on your screen to download at this time. And also for our professionals today, welcome as well. Many of you may receive 1.5 continuing education hours for attending. So please send me your ID number or accreditation if I don't have it already, so I can submit your hours for approval and send certificates out. Also, everyone will receive a post-webinar feedback email right after the presentation. So please take just a few minutes to fill out this brief survey and offer us your feedback about today's presentation. We value all of your comments that you have to share with us. And here at Elville & Associates, we always want to be a resource for your families and your planning needs. If you have an administration need to address, old documents that may need to be reviewed, or other planning to consider a consultation with Steve after today's presentation, and use today's education as a jumping off point to get your planning started. Consultations are a great way to get your questions answered, have Steve understand your specific situation. He can offer you solutions and a path forward after that. So I'd like to offer Steve and the firm a really brief introduction before we get started. And so what makes Elville & Associates and Steve different from other firms and attorneys that you might have come across in the past? And I hope this will become crystal clear to you in the next 60 to 70 minutes or so. So I'm gonna share my screen here. You should be able to see it. We're Elville & Associates, founded in 2010 in Columbia by Steve. We have several different practice areas that we focus on here at the firm on a daily basis, helping hundreds and hundreds of clients on a yearly basis. We focus on estate and special needs planning, elder law and elder care planning, estate and trust administration, how about that? Business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 9 attorneys, 12 staff members, and 3 locations, including our new Rockville office, which is getting up and running, is very busy, very happy to be there. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot here at the firm, and we do that in several ways. And we do that through our planning processes with our clients. And we have different programs to suit all families and individuals. We also focus on educational webinars and workshops in the communities that we serve each year, doing dozens of them, and I'm very happy to do them. And also by way of our accredited client care program, one of only 2 firms in Maryland we are to have a client care program accredited by the Client Care Academy in Boston. We also focus on the ideals of client education, collaboration, and compassion in mind every day with every client here at Elville & Associates. And just a bit about Steve. His work as an attorney for the past 23, I think actually 24 years now, has been centered in elder law, special needs planning, and estate planning. He's a member of many different national membership and professional organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. And Steve works to offer peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. If you haven't heard Steve present before, a very seasoned speaker, each year offering many, many webinars, workshops for businesses and their employees, speaking at conferences, and also continuing education events. And Steve was named to the Maryland Super Lawyers list for a 9th time, an 8th consecutive year in 2024. Congrats there, Steve. We'll see what 2025 has to bring here in the next few months. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. I'm very fortunate to be the executive director of. When we have more time, if you'd like to reach out to me and learn how we work to make a musical difference in the lives of children, please reach out to me. I would love to share our story with you. Having said all that, I'm going to turn it over to Steve, and he's got some great information to share with you today. So Steve, I'm going to make you the presenter here.
Thank you, Jeff.
My pleasure. There we go.
All right, I'm going to show my screen, Jeff, and I'm going to get the presentation up, and hopefully you can see it. And I'll start my slideshow. And I thank everyone. Thank you, Jeff, and thank you for that wonderful introduction and for being an ambassador for our core values of our firm and for all the things you've helped me with all these years as our webinar moderator and community relations director and all the many things that you do. And I thank everyone. Thank you, Jeff. And I thank everyone for being here this morning. I'm sitting here in conference room number 1 at Elville and Associates main office in Columbia, Maryland. And I see this beautiful weather outside today that continues from yesterday. If you're in Maryland, wherever you may be, I hope it's good weather for you. And I am very privileged to be with you today. I could not do what I do without your support of our webinar series, for our attorneys and staff here at Elville and Associates, and everyone that has helped me be able to help others as we are in the practice of law and counseling and helping people with legal technical solutions. So whoever you are this morning, special guest, financial advisor, or CPA, or other professional, welcome. And over the next 60 minutes or so, I'm going to take you through a presentation. And before I get started, though, I just wanted to say, Jeff, I forgot almost to say, it's almost time to get back to school. So children are going back to school. You wouldn't happen to know anything about that, would you?
Well, Steve, I would. Got a senior in high school now and a sophomore in high school now, son and daughter respectively. So we're both starting their sports practices, and first games are coming up. So yeah, very busy and enjoying the last couple days of summer here, but it's back to it, that's for sure.
Yes, and I know we've had a lot of parents and grandparents on this webinar today. So whoever you are, we know you're getting ready to get busier with the back to school. And Jeff, also, thank you for the great weather today. I forgot to say that.
Oh, glad to help.
All right. So as we start this webinar, I always like to get grounded. I always like to ask our audience, why are you here today? You know, what is your interest in estate or trust administration? And in all seriousness, many of you may have various situations. You may just prospectively for the future trying to decide how this will be handled in your own estate plan, or projecting into the future how your fiduciaries will handle your estate administration and what you should be looking for in educating them. Or maybe you're handling an estate or a trust administration for your own parent or loved one right now, and maybe you've suffered a recent loss. So our condolences if you have suffered a recent loss, which is really the subject matter of administration, is that someone has passed away. Or maybe you have questions about how to avoid the legal pitfalls, which is mainly what I'm going to focus on today, because it's one thing to talk about what administration is, and we are going to talk about that. And it's another thing to talk about really how to avoid the mistakes that people make in administration. So we're going to try to have a healthy combination of those two things. But before we start, I'd like to just take a minute. I'm going to time it. I would like you to take 60 seconds and really just get grounded and ask yourself, get a pad of paper, get your tablet ready, get your note taking ready, but also just say, what is it that I'm trying to get out of this today? What is my concern about estate and trust administration? Let's go ahead and start that now. We'll just do 60 seconds. Whatever a reason may have brought you here today, or reasons, just try to get grounded with those reasons. And what I hope to do today is give you something substantive, or maybe several bullet points of substance that you can take away. But as you'll find out here in just a few minutes, I'm going to be focusing on one main theme. All right, we'll go about another 15 or 20 seconds. 10 seconds. Okay, so hopefully you've been able to identify or get grounded in those things that have brought you here today and get mentally situated. And now let's get ready for the ride of information. And Jeff mentioned something that you may or may not have picked up on in his introduction. He talked about how we have processes here at Elville and Associates. And if there's one thing that I'm going to drive home today, and maybe the theme of the entire presentation today is process. And you'll notice in the title of this presentation, it's the postmortem process that is explained. And Jeff talked about estate planning process and other processes. Well, I can't strongly emphasize that enough. Process is the key to administration. Process is the key to many things. But if you were to take away one thing today from this presentation, it is that you should follow a process. Now, Jeff has provided you with some handouts. And there is a checklist, which I will hold up. You won't be able to see it clearly. There's a checklist for administration for an estate. There's a checklist for an administration of a trust. And no matter what you do or which checklist you may use, follow a checklist, follow a process. And I'm going to explain why in just a few minutes and really drill down into not only the process and how it works, but why a process is so important. All of our information that we're conveying today cannot be construed as legal advice because we are not in an attorney-client relationship, but we wish to provide, high-level information. And for those of you who wish to participate, please, by the way, interrupt us with questions or concerns that you may have. Let us know, and we will do our very best to answer those questions in a very general way. But we can enter into an attorney-client relationship if you would like to meet at some future time. So we're going to talk about process, of course, which I just mentioned, but we're going to be talking about what is estate and trust administration. We're going to be talking about some of the mysterious things or things that are shrouded in mystery that happens when someone passes away, and answer one of the biggest questions that is in America about estate planning, which is what happens upon my passing, especially with trusts. We're going to try to minimize confusion and provide support to family members. And this information is a mix of information for both prospective clients or past clients, or even if you're a client of another law firm, and financial or professional advisors who collaborate with firms like ours. And we want to talk about the legal process, and we want to talk about practical steps. We want to examine the biggest problematic legal issues in that process. But I'm also, as I mentioned, I'm going to step back from that and I'm going to talk about some of the risks and hazards to the fiduciary, the person who is carrying out this process, the personal representative or the trustee. And we're going to talk about how financial advisors and trustees and CPAs and attorneys should work together. They don't always do that, but how they should work together in support of clients. So as we start to unravel this mystery or talk about it, this is one of the greatest concerns that clients have, whether you're a client of Elville and Associates or another firm or a prospective client. This is one of your biggest concerns, which is, yes, we want to do planning. We want to make sure that we have the proper lifetime planning and death planning, but who will be there for my loved one? And this is one of the big issues, of course, one of the greatest issues. And this could be through a will-based plan meaning a will, or if someone dies with no will, as we're going to find out, there would be a probate process, the process of proving a will or proving an estate to be perfectly valid with everyone having been notified, and now we can distribute the estate. Or a trust estate, meaning a trust that has to be administered after the death of someone. So there is a transitionary period after someone dies, whether it's a will or a trust. So we're going to talk about that. And we're going to be talking about who will be there for the surviving spouse or children. What should they do? What is the process that they should be thinking through at a very difficult time? And again, can't emphasize it enough, I'll be intentionally repetitive. And that is that This should be driven by process. So preparation through planning, preparation through education. You should be congratulatory of yourselves for being here this morning. You're taking the time on a beautiful Wednesday morning. Planning, education, and organization, okay? And again, this is one of the biggest issues, one of the greatest concerns of all clients. And we're going to be going through some case examples. Okay, so hopefully what I've done in the last 10 minutes is set the stage for what I'm going to focus on, which is showing you what the process looks like at a very high level. And let's stop there for a second. Estate and trust administration is what I would call an art. I have seen attorneys that were very talented in this area. And in some respects, it's a very rewarding type of thing to be involved with. It has a certain rhythm, it has a certain set of elements, and there is an art to the administration of an estate or trust. And if you cannot handle this yourself, do not be embarrassed. Most lay people cannot do these things themselves, and they hire professionals. So there is a process, and it's very orchestrated in many ways. But it can go off the rails if we're not careful, especially if you're not familiar with these kinds of things, which most lay people would not be. So let's talk about some of the reasons why I am really sounding like a broken record this morning about process. If you're following a process, I mentioned several adjectives. It's an orchestration. It is like conducting an orchestra. It has its own rhythm. It has its own flow. And once you step back from it and you look at it, you'll start to see this, that there is a process after someone dies through this transitionary period, and when people are notified, and what are the fiduciary obligations, and the accounting, and dealing with the assets, and dealing with real estate, all of these things, and leading up to a distribution of the estate. So all of that might make sense once you get used to the information that we will go through briefly this morning. But what are some of the dangers as we will look at the process? We will look at some examples, but what are some of the dangers that you should really be aware of? And why would your time be so valuable this morning as to translate into something that really will pay off? What is the risk? Well, I made a little bit of a list this morning of the various risks and the bad outcomes that I've seen in administration. And obviously, one of the first things that you're trying to avoid in administration is litigation. You're trying to administer an estate or trust, or set up your own future administration with fiduciaries, meaning trustees or personal representatives, people that have high responsibilities. You're setting that up to avoid litigation. So litigation can happen. Litigation is very expensive, and litigation can cause a lot of destruction to your trust or estate. So we want to avoid litigation. Your fiduciaries, the people who get appointed by you or by a court to administer your trust or estate, those people could be removed. If they don't do their job properly, those people can be removed. They could find themselves in a very painful situation where they were appointed by a loved one who had a lot of confidence in them, but maybe through their own fault, but maybe not of their own fault. Maybe they just took some things for granted, or they didn't follow a process. They were removed from that fiduciary role and they were embarrassed, or maybe they were removed and they were sued, or maybe they were removed and had other liability. So this is a real risk, because any person who is a fiduciary has fiduciary responsibility, obviously, and they have to carry that out, but they also have fiduciary liability. So following a process, getting your mind around this today, just for the brief period of time that we have, you should take away that this process can save you and save your fiduciary so much pain and suffering, and not only help them orchestrate a process, but save them from the downside of not following a process. Uncle Sam, IRS, or the Comptroller of Maryland, if you're a Maryland resident, or administering a Maryland estate or trust. These types of responsibilities to taxing authorities, are extremely important because this can represent a downfall for the fiduciary. They didn't deal with the tax issues correctly. So now there's all kinds of problems. There's all kinds of liability. There are beneficiaries who are upset. So this is one of the risks. Estate tax, while we're on taxes. So estate tax issues have to be handled correctly. Deadlines have to be met. Estate tax returns have to be filed. Inheritance tax issues. Maryland is one of the jurisdictions that does not tax everyone like some jurisdictions do on inheritance tax. So Maryland has abolished the inheritance tax as to most beneficiaries, but not all. So if you're dealing with an estate or trust where there is inheritance tax, we have to deal with that because that is a very serious issue and can result in penalties and interest and all kinds of breach of fiduciary duty and all of these things. Dealing with beneficiaries. So beneficiaries have to be provided with information. They have to be provided with notice, as we're going to see. And another, and maybe the last thing that I'll mention, just trying to drive home the importance of process, is the loss of control. So let's say that you were appointed as a fiduciary, or you're getting ready to appoint someone in your own trust or will, and that person you're expecting to be in control, or maybe you are in control of the administration. But now you could lose that control if you either don't get appointed in a timely way or follow the rules of the process, or you don't follow the process itself as to the fiduciary responsibilities and you lose control. Not only were you embarrassed and humiliated, let's say when you were removed, but you also lost control, and your loved one who appointed you expected you to remain in control for various reasons. So for all of these things, even though I've been somewhat negative over the last few minutes, is really by design. I'm trying to drive home that we're going to do more here today in our time together than just look at how it's done. I want to really give you some of the underlying concerns that you should have, and now you're on notice that you should have those concerns, that when you assume this role, or someone you appoint assumes this role, they are assuming a lot of responsibility. Some of you have experienced this and you know this. Others of you have not experienced this. So hope I've made my point. There should be a process. You should be driven by the process. And by following the process, you can hopefully avoid the minefield of problems that could occur that could be painful or costly. All right, thank you for sitting through that as I kind of made my points there and set the stage for the rest of the information. So it's about 10:23, we're on time. I'm going to give you some case examples here. Now, none of us knows what our estate is really going to look like when we pass away, or our trust estate. But if we can, and I think this would make a lot of sense to all of our listeners this morning, we want to do the very best we can to clean this up, to make it the way it should be, to give a path forward to our fiduciaries and not leave our fiduciaries in a mess. We're dealing with a case right now where someone who was just a very lovely person left quite a mess, and it's got to be cleaned up, and it's really unclear. There's very much such a mess that it's very unclear about what direction to really go in, and so this is a problem. So to maybe the first step, which is probably very clear, is we want to make sure that we do proper estate planning during life, whether that's a will-based plan or a trust-based plan. We want to make sure that our beneficiary designations are correct, and we want to make sure that if we have a trust, the trust is funded, right? And now we're making things as easy as possible for our future fiduciaries. But you may be a fiduciary right now who is dealing with a mess or dealing with something that's not quite as clean as it should be. So by following a process, by taking professional advice and having a team of advisors, you'll be able to get through to the end. So none of us knows what our own individual estates or trusts are going to look like when we pass away, but we can do our very best during life to get that as clear and cleaned up as we can. Now, who knows what you're going to end up with, or a fiduciary is going to end up dealing with. And this is where, again, they should step back, not try to do self-help, not try to do it themselves, but to hire professionals to provide direction. Okay, so let's look at some plan types, and some of them are clear, some of them are non-probate. There's a trust involved. There's no estate. Some of them, a survivor is in a different situation than we ever thought. And we've seen some of that just in the last 2 or 3 weeks here at Elville and Associates with some client situations. And then we have no plan or a poor plan. So let me just give you some brief fact patterns. You could actually make up an innumerable fact patterns about all different kinds of things, and you would not be wrong. So here in this fact pattern, we're just simply saying that Felix is a single person. He had one child. He has a residence, very prototypical situation. He was an older man. He died at age 77. Even though people are living quite a long time today, generally speaking, this man died at 77, which today is not old. We've had people, many people live well past 95 or over 100. But here he died with a residence and some cash, CDs. He's got an IRA. There's savings bonds. He's never made gifts during life. He had Social Security, and he did have a will, and he left everything to his child outright in that will. So this is a prototypical situation where what are the probate assets? Well, the assets that have to go through the will are the assets that are in Felix's own name. They have no beneficiary. Those are going to be the probate assets, and they have no joint owner. So the IRA will not go through probate because we're going to assume it had beneficiaries, okay? But everything else is going to go through probate in this hypothetical. The residence was in Felix's sole name, the cash was in his sole name in those various accounts, and the savings bonds were in his sole name. So in this fact pattern, you can clearly see that the majority of his assets are going to go through the probate process, that his son Charles is going to have to open an estate, he's going to have to deal with it, and we're going to look at the process of how that's done. And eventually, he is going to distribute the assets to himself. Notice the IRA, Felix is going to have until the fall of the following year, after Charles, is going to have until the fall of his father's death, after the year of his father's death, to make a death claim on that IRA. So all of this is in probate except for the IRA. Now, as we look at a different situation, here we have a married couple, just to give you a feel. Here we have a couple where a first spouse has died, the first spouse to die. This man was also young. He died at age 69, leaving a relatively young surviving spouse. And the professionals on this webinar, we see this many times. But this person, if you look down at the bottom, they had a revocable living trust. Now, for those of you who are not familiar with this, a revocable trust is not magical, it's not mystical, it is just a substitute for a will. A person could have a will, or they could have a will substitute, and that's what a revocable trust is. And let's just make the assumption that this person did everything they were supposed to do, this couple. They created this trust, but they also funded that trust. They put their non-retirement assets into this trust. So they had a fully funded trust. So now, is there a lot to do here? Well, there are some things to do. We have a surviving spouse, we have a residence that comes to them, we have cash and CDs. That surviving spouse is going to make death claims on the IRA, or IRAs or 401ks. They're going to make death claims on the life insurance. The joint brokerage account is going to come over to the surviving spouse. And look, they had a residence in a separate state. So here in this example in Maryland, they had maybe a shore property over there in Delaware. So all of these things are going to come to the survivor. And we didn't add up how much this estate is, but it's a fairly substantial estate. But there are certainly trusts and will estates that are much bigger than this. But here we're going to decide things after the death of the first spouse. Does the surviving spouse, Janet, need to do anything as far as tax elections? Does she need to do anything about retitling assets in her own name? And the answer is yes. But this just gives you an idea of what certain fact patterns may look like. Now here in this third fact pattern, not trying to be too creative, we are simply saying that Janet, the surviving spouse, survived another 20 years. So that's not surprising. And when she was living her life in the years to come, her life changed. She moved to a continuing care retirement community. She continued to have cash and savings, but look at how big her IRAs have grown and her brokerage assets, okay, and her life insurance. And she sold that Delaware property and now has a Florida property. So things can change in the future. But now, what did Janet really have? She had a single person's revocable trust, and now at her death, everything is distributable to children. But just to show you why your fiduciary responsibility or your appointed fiduciary's responsibility is broad in one sense. Here we have a child who's disabled. No one thought this would happen, but this otherwise healthy child, over that 20-year period since Jack died, that child has a brain injury or some other disability. And now, what are we going to do with that? So there could be a way to house that child's share in a special needs trust under the terms and provisions of Janet's document, or there may be other backdoor ways to try to protect that child. So in my opinion, the fiduciary has a responsibility to do this and not just to distribute out the money, and all the money could be subject to dissipation very quickly because of the disability. So these are the broadly construed fiduciary responsibilities of a fiduciary or trustee. But again, some people would look at this very narrowly, but I think it's wise to look at it very broadly. So as you look at all of these things, what are some of the characteristics very quickly? Well, the continuing care retirement community, that deposit, if it's coming back or a portion of it's coming back, it may not come back for 6 to 8 months. The IRAs, the children are going to have to make death claims on those IRAs. The brokerage account is going to be distributed according to the trust. The Florida residents will avoid probate because it was in this trust, so there's no probate in Florida. So all of these things factor in. For example, when that disabled child in this example is getting his or her IRA money, perhaps that IRA money can be sheltered in a special needs trust of a different kind called a first party trust. So there are various rules, and if you're following a process, if you are taking the advice of your fiduciary advisors, your attorneys, your CPAs, you are going to be walking on the straight and narrow path. Here in our last fact pattern, which we won't spend a lot of time on, this rather interesting scenario is one I've actually seen before, although this is a fictitious example. Here a person died with no will, and he had 2 children, but he was also still married, but they were separated, and there was a very different kind of life situation going on there, and one of the children is in bankruptcy. So basically, this estate of this man is going to get administered as a basically an intestate estate, an estate where he had no will, but it's still going to be distributed according to the laws of the state, and people have to be notified. And as you can imagine, this is a messy situation. You'll notice again that savings bonds are in this example. And why do I continue to show you that example? Well, savings bonds are what is called IRD, income in respect to a decedent. And all that means, in simple terms to me, is that savings bonds have to be accounted for as far as income tax if someone dies still owning them. They are part of the probate estate for this particular kind of situation where the man owned those in his sole name. So those are going to have to be dealt with, and the income tax might have to be allocated in various ways to try to reduce the income tax. The inherited IRA to the children, those have to be claimed and so forth. And there could be a spousal elective share here. There could be various things. So I only show you these 4 examples just to kind of whet your appetite a little bit about all the numerous types of situations you could encounter. And certainly what we want to do, if we can, is either follow the best patterns we can during our lifetime. But if we do inherit a situation like this, be guided by the straight and narrow path of a process and your professional advisors. All right, so we want to minimize confusion and we want to provide support to loved ones, personal representatives, and trustees at a time of crisis. So we want to have empathy, whether you're a professional or whether you're just a non-professional fiduciary or a professional advisor. We want to have empathy for the family members. This goes without saying. We're going to have to ask certain practical questions. What kind of support does this family have? If you are a professional, your whole firm should be committed to these core values. And we want to be creative about resources. Remember that people are looking for resources, and many of the advisors on this webinar today are excellent at having substantial resources available to people and being connected to those resources. And the professionals need to have this ability, this empathy, to act as a counselor or coordinator, even if they are not themselves going to be acting as a fiduciary. So we want to assure either beneficiaries or clients that they are taken care of and that there's no hurry. I recently met with a surviving spouse who was very brave and came in very, very soon after the death of her spouse. And this person should be commended for this. But in most cases, not all, in most cases, there's no real hurry to jumpstart the administration. But within a reasonable time, it does need to be started. We need to make sure that all advisors, the collaborative team that is supporting fiduciaries, are coordinating together and working together, that everything is in order, that we're making sure of that prior to death and also after death, trying to assure people that are in need that everything is in order, that we're being supportive of final arrangements, and we're also dealing with family-related issues, if there are any. And we know in many families there are family-related issues. And of course, expressions of sympathy and being very sympathetic to these things is very, very important for family members as well as professional advisors. So let's talk about what the legal process now. I talked to you about some of the pitfalls and setting the stage, why this is so important, but let's actually talk about these processes. It's a little bit short of 20 till 11, and we're just going to move quickly through these. Again, you would have to spend years in mastering these types of processes. Today, my purpose is to give you a feel for what administration is and the downfalls or the pitfalls. So we're going to talk about probate versus non-probate. We're going to see that these are similar yet different processes. We want to use the checklist, of course, for critical dates, and we've talked about organization. Okay, now I'm going to stop for just a second and take a sip of water. Jeff, if there's any questions, I hope you'll interrupt me, but I'll just keep going if there aren't any.
Thanks, Steve. Just had one about 10 seconds ago, so you're right on time. Question is, please discuss the instances when the Maryland inheritance tax will be applicable.
Thank you very much for that question, and I'm going to go ahead and take the opportunity to answer it right now. So a good example of this would be, I pass away and I leave $50,000 to my niece, but I also leave $50,000 to a grandchild. Well, my grandchild is a lineal descendant, so my grandchild is exempt from Maryland inheritance tax, but my niece is not. So my niece is subject to the 10% Maryland inheritance tax. So that is an example of how Maryland has abolished the inheritance tax pretty much as to all lineal descendants, but as to those more arm's length relationships, there is an applicable Maryland inheritance tax. The inheritance tax is not going to be applicable if I gave my niece that $50,000 and more than 2 years passed. I was still living and I gave her my $50,000, but I survived 2 more years. That's going to be exempt. But if I died and left her the $50,000, or I died within 2 years of having given her that $50,000, it's going to be subject to 10% inheritance tax.
Great, thank you.
Thank you, Jeff, and thank you for that question. So again, at a very high level, we're not going to spend a lot of time. We're just going to get a feel for this. Someone has passed and there's a date of death and there is a death certificate issued. Now, Death certificates are not fast these days, I'm finding. So death certificates are eventually going to be issued, and that's important. The personal representative in this case, because we're going to make the assumption that there has been a will. And a will, by its very nature, goes through probate. Probate is the process of proving a will to be valid. So here, someone has said, I want to petition the court to become appointed as the personal representative. So they are appointed with a letter of administration, an official letter with a raised seal that says they can take charge of the estate assets. Now, again, there are various situations. This is the prototypical situation. 3 months later, there is an inventory and an information report due. So the Register of Wills basically says in Maryland, and I'm being very general here, very general, well, this person died and you're telling us they have these assets, but now 3 months later, you have to give us the value of those assets. You have to give us an appraised value. You have to give us the date of death values of these brokerage accounts and so forth. So this is due within 3 months. The information report has to do with inheritance tax. So that was a very timely question. The information report basically is 4 questions. And in essence, it says, is anyone in this estate subject to inheritance tax? So usually the answer is no, but it could be yes. And this is answered and submitted within 3 months. Now, there are valuations, there are alternate valuation dates for estate tax purposes. Claims against the estate have to be 6 months from the date of death, but some registers of wills treat this differently from the date the estate was opened. So this is an issue that's a little bit ambiguous, I think. Spousal elections have to occur. So spousal rights come in. There is a new spousal elective share law that says that surviving spouses cannot be disinherited more than a certain amount. So these laws come into play, although not every day do we see spousal elections. Disclaimers, which are tax elections basically, or elections that someone who receives an asset is not going to actually take it. They're going to disclaim it either back to a trust or they're going to disclaim it to another person. That has to be done within a certain period of time. And federal estate tax returns and state estate tax returns have to be done within a certain period of time. And for those of you who are interested in estate tax, remember that if there is estate tax due, it is due within 9 months of the date of death. And that is a very scary prospect if a person does have a taxable estate. What is a taxable estate right now? For a single person, more than $13.61 million, $13,610,000 on the federal level, and $5 million for Maryland on the state level. A couple can exempt through the use of portability, which we're going to talk about very briefly. They can exempt double the exemption amount, 13.6 times 2, and next year it will be higher. But in 2026, the law is due to reset back to around 5.5 million, adjusted for inflation, to be about 7.1 or 7.2 million per spouse. So we will see where the political winds go and whether that law will actually go away, which we expect it to do. Now, elections have to be made for other purposes on tax returns, and one of those might be what is called the marital trust election, the Q-tip election. I just mentioned the portability election. This has to be made within 60 months. It's a long time for the federal, but within 9 months for Maryland. So there are various nuances there that have to be understood, and this is where a fiduciary could really trip up, or a surviving spouse could really trip up. The administration account is due in a regular estate within 9 months, and then there could be subsequent administrations, and then look at retirement plans. There's a certain timeline for those retirement plans that they have to be claimed, and that is by the fall of the year following death. All of these things are nuances that the average layperson is going to want to seek advice and be guided by a team of advisors. The Secure Act, remember, said that there are only 5 types of people who are exempt from the 10-year acceleration of income tax. In other words, the IRA has to be taken and distributed within 10 years and all tax paid and so forth. So we have to be aware of the types of beneficiaries that could receive IRAs and whether any of them are exempt. Still continuing, there are fiscal years and so forth for tax return purposes and certain closing letters that could be obtained from IRS if there are state tax issues or other issues, and dates where amended returns can be filed. Now, we went through that really quickly, but I'm doing it on purpose because I don't want you to necessarily focus on all of these steps and feel inferior if you don't understand all these steps. Just remember that they exist, and your awareness of that is going to be enough. Now, let's look at a non-probate trust administration. One of the biggest questions across America, and maybe around the world, as far as U.S. estate planning goes, is it's very simple. I have a revocable living trust, which is what? A substitute for a will, and I've got that trust fully funded. I did a great job with that. My IRAs are outside the trust, but my non-IRA assets are still inside that trust. That's where they should be. And now at my death, what happens? Well, this is the big question. What happens to that revocable trust that could have been changed at any time? Now what happens? Well, the answer to this question is relatively easy. That living trust becomes irrevocable. It's just like an estate. When someone dies with a will, that is irrevocable at their death. Well, that revocable, changeable trust now becomes irrevocable, and it has to be administered. And that is what's happening here. So in theory, and this is a question rhetorically for you to answer, in theory, is a revocable trust distributable immediately, the moment of death? And the answer is yes. So a good example of this is a person dies and they have only one child. And that trust that they died with is fully funded, and now it has to be administered at their death. Well, that only child could distribute those assets immediately. There's no process. But in reality, there is at least some process. So when we think about a trust, we still should think about process. Let's take a second example. Let's say there's 3 children, and one of those children is the fiduciary, okay? Well, even though there's no probate, there still is a process. That person has a fiduciary responsibility to who? Well, to themselves, but also to the other beneficiaries, okay? And they are entitled to notice. They are entitled to understand what the date of death values are. Since 2014 in the Maryland Trust Act, which really got Maryland up to speed to where it should have been a long time ago, the Maryland Trust Act says that all beneficiaries have to be notified and they are entitled to information. So you see that fiduciary has fiduciary responsibility even though it's a trust. And final tax returns have to be filed, and estate tax elections and other spousal elections might have to be, and all of the same things in essence have to be addressed or should be addressed. And that's what I'm trying to drive home here today, is that even though this is a non-probate situation, there's no register of wills looking over the shoulders of the personal representative or trustee, there still is a process. And why would that be? Well, why is the importance of that, I guess? Well, because ultimately, as we look down the list here, we want that fiduciary to be released. So take a look at this slide and the bullet point that's at the top of this slide. Here, this child did a great job. They did everything they were supposed to do. They were transparent. They provided information. They provided notice. They provided a final accounting. Are they entitled to be released? And I think the answer is absolutely yes. They should be able to require a release, a waiver, and a refunding agreement to all of their siblings or all the beneficiaries to sign off on and say, I understand that I've received the accounting, I have received information, and I am releasing you from liability. You've done a great job, and now you can give me my distribution. So I think that's the essence of fiduciary responsibility, that you've done such a great job that you're entitled to be released, and you are released, and now you're going to make those distributions only after you've been released. So I think that makes sense to most people. So hopefully we've seen in a very brief period of time that Probate and non-probate still may represent similar processes. And I think that's one of the major things that most people don't realize. And again, the whole purpose of having a revocable trust, many of you will say, well, is to make things easier, to make things less costly, to make things more streamlined. Well, Steve, why are you going through such a huge process? Well, it's because even though it's a trust, and even though it's not done under the auspices of the Register of Wills or the oversight of the Register of Wills, it still has fiduciary responsibility, and we want to make sure that it's done correctly, and we want to make sure that the fiduciary upholds their responsibility and is not hurt or removed or makes mistakes that could cause litigation. So there's a process. All right, let's talk about the practical steps. So we talked about the legal steps, we've talked about the legal pitfalls, we've talked about using a process. Well, remember I said there's no real hurry. Well, a surviving spouse, probably within 3 weeks to 4 weeks, should come in and start this process. Now, if it's possible to start it sooner, fine. But unless there are urgent issues like rental real estate that's involved and what's going to happen with the management of these properties, or there's a business, probably there can be a reasonable period of time to get it started. Coordinate with advisors, use checklists. There we are again. Organization is the key. Have an inclusive process. Now, this is where it becomes a bit daunting to try to explain. When someone is a fiduciary, they do have an obligation to provide information and so forth, but there are limits to their obligations to have to communicate. And to me, that's an ambiguous area. So I think where possible, it's going to be wise, most of the time, not always, it's going to be wise to have what I would call an inclusive process instead of an exclusive process to try to minimize tensions and deal with any issues that may come up. We want to make sure that surviving spouses or surviving children who are in the process of grief are provided with appropriate support. And I think most of the time that does happen. Remember that the surviving spouse, again, should be methodical but not hurried. And a surviving spouse should address his or her own estate planning, and most of them are keenly interested in doing that. So again, when emotionally the time is right, that needs to be addressed. Again, organization and general readiness, traditional document storage. Where are the documents? I handled a situation recently, just in the last week, where this wonderful person who had passed away provided clear instructions about everything and was very methodical. This is the ideal, including electronic archives and passwords. Now, what are the most problematic things? Well, I talked about some of the legal pitfalls, like some of the personal things, some of the most daunting things that could happen to a fiduciary. But let's talk about the more high-level legal issues that really are of concern. Well, these are not necessarily liability issues, but these are legal issues. So we want to make sure that assets are titled properly prior to death. If you know someone or dealing with someone who, God forbid, is having health issues or they're very significant end-of-life issues, get all assets titled properly. Accelerate that, because usually things happen quicker than we think sometimes. We want to make sure that after death, the valuations are done properly. This is a very critical thing. A lot of people just skip over this. Caution in the retitling of accounts. This is the third bullet point. I see many advisors and clients retitling assets very quickly after the death of a spouse. And to me, this is really unwise. And the reason for that is many people inadvertently skip over the provisions of the trust. They don't follow the provisions of the trust between spouses. I wouldn't say this is a pervasive problem, but it is out there, and I do see it quite often. We want to make sure that we're methodical in the retitling of accounts and the acceptance of accounts prior to, we want to be cautious not to do that prior to the actual formal administration, because we could be shooting ourselves in the foot. We could be contrary, not following the provisions of a deceased spouse. in their desires and their provisions of their documents. Inheritance tax, we talked about this. The portability election. This is an heirloom. This is like gold for the surviving spouse and the children or the family to be able to port the unused exemption amount of the deceased spouse. This is something that in most cases should be done, in my view, not in all cases, but it's an heirloom that should always be, I think, used if it's reasonably appropriate at all. It should not be wasted. The Q-tip election, which is the marital trust election, if there was a spouse who died and left everything to a surviving spouse in trust, called a marital trust, that Q-tip election has to be made. Creditor claims. Creditors can be problematic. I've never seen it with a revocable trust, but since 2014, creditors are allowed to make a claim against a revocable trust in Maryland. So it's theoretically possible. So therefore, in the Maryland Trust Act, trustees may notify creditors and give them notice that someone has passed away. And you may say, Steve, well, wait a minute, I thought the trust was private, so why are we doing this? Well, I would just say it is a best practice, even though most people who have revocable trust either die with no creditors or it's kind of inconceivable that a creditor would make a claim. I think a best practice would be notify creditors through the Maryland Trust Act, which is literally an advertisement that can be run. And in doing so, you're foreclosing the claims of any potential creditors in the future. And I think that's a best practice. We want to communicate completely with the entire team. We want to make sure that there's a quarterback of that team. This is not always possible. If you're a client or a prospective client and you have an advisory team, I would talk to them about who's going to be the quarterback of this team and make sure that they're working together and communicating. If you do not have an advisory team, I recommend that you meet with us and we'll help you develop one. Again, we want to invest significant time during our lifetime or during the lifetime of our loved ones who we know are going to pass away to make sure that all assets are aligned properly, beneficiary designations are aligned properly. Again, we talked about expediting meetings, expediting objectives if we know there's an obvious illness that someone is having that could be life-threatening. And we want to ascertain the person's wishes and encourage the use of memorandums. So a memorandum could guide through the administration process, could guide through the further administration process if there are trusts either under a will or a trust. There are further trusts for the benefit of beneficiaries. We want to encourage the use of organizational tools, encourage the education of family members. This is something that Elville and Associates has a core value of education, but not only of clients, but of family members. Systematic organization, disseminating information, assuring the client or assuring your loved one that is concerned that they have your full attention and that everything is going to be in order. This is not only a very humane and wonderful thing to do, but it is the right thing to do. All right, well, Jeff, we've reached 10:58 and I was shooting to be done before 11 o'clock and here we are on time. I just want to encourage everyone to congratulate themselves for setting through that and really getting a sense of what administration is. The high-level legal pitfalls, the emotional, personal, and fiduciary pitfalls, and a general idea of the process, and a general idea of just how enormous of responsibility it is, and the various scenarios that can occur. So we suggest a path forward because we don't want to just educate, we do want to give you a path forward. So we're here to advise and counsel. So set a consultation with us if you have any questions. If you are not administering a trust or estate for someone or prospectively doing that, but you just want to set the stage for your own administration, please come in. We'll talk to you, answer your questions. You'll see here in this bullet point list, we want to look at your questions. Please make a list. Please come in. We have high-tech facilities in our various locations, and we want to give you the time to think. We want to help you with, create an advisory team that can give you confidence or give your parents or other loved ones confidence. And we also want you to know that there's nothing to fear. So when you share information with an attorney, whether it's Elville and Associates or another law firm, there is an attorney-client relationship when you come in to, consult with us, and that's whether or not you become a client doesn't matter. There are attachment of attorney-client privilege and confidentiality. So there is nothing to fear, and we just encourage you to enter into this kind of conversation if you have need to do so, and we would be privileged to advise you. So hopefully you've taken away some substantive bullet points from this presentation. Jeff, I'm going to turn it back to you, and I wish everyone a beautiful week and day ahead.
Well, thanks, Steve. Lots of just really great and important information in there. Thanks for a great presentation. Anytime we do this presentation every quarter or so, I always think back to when I was named the personal representative of my aunt's estate a few years ago when she passed away. And I was fearful, really fearful, that I was going to make a mistake, not follow the right process. So even though I've been here for 11 years, obviously I'm not an attorney, so I enlisted the help of the firm for a couple of reasons. I wanted to make sure the process was done correctly. I didn't miss anything. I wanted to carry out my aunt's wishes to the letter and honor her in that way and make sure that the beneficiaries were taken care of. And I'm glad I did. For people that go it alone, that's one way to do it, but I personally could not do it. So if we can be of resource to you in any way for this process through the administration, let us know. Always here to help, and I can say it was very helpful to me. So let's answer a couple of questions here. Now would be a great time to get those last questions in here to Steve, and we do have a couple here to start. Steve.
Great.
First one is, please advise how to leave my husband's and my primary residence to a child and determine a value so he or she can pay or buy out the other beneficiaries. The real estate market is so inflated.
Well, thank you for that great question. I think that this is something that I've just seen in the last week. This is something that comes up a lot where one child will receive real estate and so forth. So I think in the planning process, each will or trust has various elements. Who gets my tangible items? Who gets the balance of my estate? How are they going to get it? What happens if there's no one living? And what happens if I have a special situation like this? So I think that through various equalization clauses, or maybe what I might call an equitable adjustment, depending on whether you're using a will or a trust and how the assets are flowing, how much are there in IRAs and 401ks, and how much are there in non-retirement assets. Depending on how the assets are flowing, I think you would be pleased that there are various ways of dealing with this through an equitable adjustment clause of some kind, and requiring a certain process after your passing about adjusting the shares and appraisals, and maybe averaging 2 appraisals, whatever that process is going to be. But I think you would be happy to know that you will be able to articulate this kind of thing through thinking through it and having the time to actually sit down and get advice about it. Great question.
Thank you. Next question, also a good one. The principal residence of a married couple is located in Maryland. Spouse number 1 dies. What actions, if any, are recommended regarding retitling the residence on behalf of the surviving spouse during the remaining lifetime of spouse number 2?
That is an excellent question, and I get so many of these types of questions about that exact issue that I'm just going to try to give you some peace of mind about this. I think many people feel the necessity to go ahead and retitle the residence in their own names, and maybe through your further estate planning as a surviving spouse, maybe you will do that for various reasons. But let's say that you never did that, which you probably should revisit your own estate planning now that you're a single surviving spouse. But basically, looking at the deed itself, if it is a typical deed that was, tenants by the entireties, husband and wife, husband ownership, and now the survivor of you has the sole ownership of the property, there is no need, generally speaking, to retitle or do a new deed to title the property in your own name, because if you never did that and then someday you sold the property, there would be a note in a notation in the new deed, the deed of conveyance, that your spouse died on this particular date, leaving you as the sole surviving, tenant or the owner of the property. And now you are conveying the property to a new person. So there is no real need, in my opinion, to retitle the residence just for the sake of putting it in your own name. However, some surviving spouses prefer to do that just to clean everything up. But in essence, I don't think it's always necessary. But you may do it as part of your own continuing estate planning and as you face the future for your own planning. Thank you.
Okay, thank you. Looks like those are all of our questions now, just a few, but a few really good ones. So thank you, everybody.
Thank you.
I'll be sending out, as always, the video link from today, the slides and the checklists, once again, to everybody, and some other resources that can be of help to you. I'll have those out later this afternoon. And as far as our presentations going forward, usually I have this up right in front of me. Boy, oh boy. I can tell you that, let's see here. On Monday, we're going to be at the Friend's house. Lily Hummel, who's our principal attorney with the Rockville office, is going to be talking about leaving a legacy and advanced directives. So make sure you reach out to the Friend's house and RSVP for that. I'll send out information about that. And next Wednesday, we're going to be talking about trustee selection and how to choose the right one for you. And that's Wednesday at 10 with Steve. That is our quarterly presentation. And then the following Thursday, we'll be talking about planning for the future and using real estate as a vehicle. And that's going to be with Marie Ritzenberg of Main Street Home Loans, part 3 in her ongoing series with us. I did this off the top of my head. So hope to see you there. I'll send out information for all those presentations in my follow-up as well. So we appreciate you being here today. Hope you have a really great rest of the week. And thanks again for your interest in Elville and Associates. Have a great day.